You know, the final point has to do with the duty to present counter-arguments. To some extent, that is contextual. You know, you rarely see an opinion from a large Delaware firm on a question of a corporate transaction, which tells you that you may do X, Y, and Z on the basis of the corporate law of the state of Delaware, that in the opinion that you give out to the stockholders also tells you. And then on the other hand, there are all these counter-arguments. You may get sued by the shareholders. Other things may happen that a court may not like. It is just not simply empirically true that a treatment of counter-arguments, any treatment of counter-arguments, much less a thorough treatment of counter-arguments, is considered essential in the giving of advice in the legal profession. In fact, you know, there are examples on the books of perfectly competent legal advice that is given in one sentence. You know, there was some old story about some Eisenhower flunky who got into some hot water and called his fancy New York lawyer, and the advice, which was impeccable and correct, was resign immediately and in writing. And so I do think that there is an issue here as to whether some of these rules are being made exposed for the purpose of coming up with a standard that was not the antecedent standard and is not even today a standard that we would be prepared to apply to the bulk of the legal profession. I mean, it's okay to talk about them in a normative sense as to whether they ought to be the standard, but if that is the tenor of the discussion that we are having, maybe we shouldn't engage in a broader slander of people who were doing their best in public service by calling them incompetent or unethical.
Professor?
Yeah, I guess I'll respond to that, take it somewhat more technical. I guess the abstract stuff doesn't work. Somewhat more technically, I think the reason you don't see a lot of freestanding 2.1 cases is that often conduct that violates Rule 2.1 violates some other rule in a more obvious way. So the sleeping with clients cases is clearly a conflict, an impermissible personal interest conflict. Under Rule 1.7, it's just a clearer violation of that. It's a breach of fiduciary duty. It's actionable as that. It's just clearer in that way. So there tend not to be a lot of freestanding 2.1 violations. It gets tacked on to something else. And so there's not a big body of law interpreting Rule 2.1. I'm the first to admit that. Part of the problem, the reason I'm falling back on all this abstract stuff, is that we're kind of at sea in the government context because there aren't effective remedies against government lawyers for immunity reasons and other reasons. There's just not a lot of doctrine out there. So for Professor Estrada to say there's not a lot of doctrine and then to say you can't just do this abstract normative analysis is kind of to cut the legs out from under any possible analysis that can be raised of the ethical obligations of government lawyers. I mean, the reason I fall back on 2.1 when I'm asked this, when people say what rule governs this, is it's the only conceivable rule that governs it. That's not to say that it's a great fit, but it's the best we can do, and I think that if you are going to isolate out the conduct of these lawyers and analyze it in ethical terms, that's the rule to use. But because most of these rules have developed in the context of private lawyers, because that's where the energy is and that's where the controversy is for the most part, there's not going to be a lot of doctrine applicable here. So, you know, so there is a sort of absence of formal legal regulation, which is why I've been offering all of this theoretical stuff. Now, on the stuff on the Convention on Torture, my only point is, and I don't want to get deep into the weeds of international law here, my only point is that the non-derogability provision in the Convention on Torture could potentially, I'm not saying certainly, could potentially be relevant to the interpretation of the federal criminal statute to the extent an interpreter wants to know, are these sorts of contextual factors, national security or whatever, to be taken into account? Do they bear on the proper construction of the statute? Do they bear on legislative intent? Are they aids to interpretation? The non-derogability as a matter of international law may be relevant. It may be a part of a sensible statutory interpretive practice. Not if we're talking to France, but if we're trying to figure out the meaning of a federal criminal statute. This is what I mean by the craft of lawyering. That might be something that lawyers can look to. It might not, I don't know. But what I mean is that lawyers engaging in the process of interpretation may or may not. I think Professor Estrada, Mr. Estrada and I agree that it's contextual. It may or may not be relevant that such and such. But if it is, then it's something that bears on the analysis of the advice the lawyers gave.
All right, I think we're ready for questions from the floor. There are microphones at both ends, and you will need to be mic'd so we can pick up your question. So if you want to get in line, we'll start. Did you have a response while we're getting in line?
Yeah, just a brief one. I mean, I'm certainly not one to advocate cutting the legs down from under any ethical rule. I am only simply saying that we should not sort of make up ex post what the rule meant all along. And if we don't have guideposts that existed at the time of the decision that point to you to the conclusion that this was not okay, then you should not retroactively, at a high level of generality, come back and saying, oh gee, now with the benefit of 7 years of hindsight, I can tell you now why I think it wasn't okay. You know, the point about whether foreign law is relevant to the interpretation of domestic statutes is a good one, and that is actually part of a broader debate in our legal culture. There is a fight every time we have a confirmation hearing about whether a candidate, especially one for the Supreme Court, really thinks, for example, that foreign law is relevant to the interpretation of our Constitution, and not to denigrate that debate. I can see a reasonable argument why people might say that, if I think a long time. I might see it even better in the context of a federal statute, but I think, to me, it's fairly implausible to say that just because you can frame one side of that debate, it is appropriate to use the rules of professional responsibility to attempt to take somebody's license who doesn't agree with you in the debate.
All right, question over here. Is it on?
Nope.
All right, I'll try to talk very loud. My question will take from the abstract down to concrete, and the example is this. We all know Attorney General Holder has reopened the previous declination of prosecution against CIA employees who were following these memos for doing interrogation. The Washington Post and New York Times reported two facts about that. The first, that he had made the decision after clearing his schedule and spending 2 days reading the CIA Inspector General's report. The other fact was that his senior staff admitted that he did not read the declination memos by the career prosecutor who made the decision. My question is, for a government attorney to take that kind of a legal action, which has that kind of serious consequences, is that unethical? Does that violate normative standards on prosecution?
Yes, of course, if the facts are as reported. I don't know enough about this, so I will steal a page from Mr. Estrada, and I will say that on the facts as you have presented them to me, this is my response, and if the facts should change, then my response may be different. But, but there's an advice of counsel defense that presumably would cover CIA agents who relied in good faith on the advice of counsel, and I think from what I know of the facts, there would be a very good reason not to prosecute CIA agents who acted on the advice of counsel. The reason I gave the little prelude is that I actually did not know that Holder had decided to prosecute agents who had acted on the advice of counsel. I thought the decision was very clearly not to prosecute agents who had acted on the advice of counsel, except to the extent that they engaged in conduct that had been deemed unlawful by counsel. So my understanding, and I could be wrong, my understanding of this is that there's a very careful bifurcation of that conduct which fell within the authorization that was given by counsel and that extra authorized case. If that's incorrect, then I don't know.
I mean, I'm probably the last person to be clued in on the inner workings of the Obama administration, but as I understand it from the New York Times and other papers, which again you can apply the 90% discount to that, the decision that was ostensibly made was to investigate people who had been previously investigated and as to whom a decision not to prosecute was reached, but only insofar as the investigation was intended to look at whether they departed from the guidance that had been given by counsel. And if that is actually what happens, I I could not think of any reason why Holder would be acting unethically in that. I mean, there is no right that anybody has not to be investigated by the government, would that there were. And that in itself, if it's targeted to determining whether you comply with the legal advice, would seem to me at that very general level to be fairly unobjectionable.